Good afternoon, everyone. My name is Judy Blake, and I am a program coordinator with Family to Family Network. We are here in Houston, Texas. We have people with us throughout the state and very excited to be presenting this information by our wonderful friend, Mr. James Soto. He is a phenomenal and dedicated attorney here in Houston, Texas. He is bilingual. Yay, go James. In my next life, I've always said I'm going to be bilingual, and it's not happening in this life, which is really disappointing. But anyway, we are very happy to have you all join us. Feel free to ask questions throughout or put in the chat if you have any questions, and we are happy to get some clarification on that. I want to take just a moment and introduce my amazing colleagues. First, we have Leslie Lawson.
Hi, everybody.
And she has been with Family to Family Network a long time. We love Leslie. She is a wealth of information. We also have Christina Zavala.
Hola.
She is our bilingual colleague and helps our Spanish-speaking families and all families as well. Later on, hopefully, Leonela Castillo will be joining us as well. So we are going to go ahead and get started with Jim Soto. Thank you so much, Jim.
Well, it's a pleasure to be here, and thank you for inviting me to this event. And I understand that next week there'll be the presentation in Spanish. So if anybody out there wants to share that information, let them know that next week it'll be at a different time, but just check with Judy or Leslie or Christina, and they'll get you that, and we will cover this in Spanish as well. And that's always fun.
Yes.
Yeah, it'll be 6 p.m., June 19th.
Mm-hmm.
Great. So this is a safe place. There are no silly questions. I've been doing this for many years, but for you, it's maybe the first time around, and it can be a lot of intimidating topics, but everything is safe, and I want this to be a safe space. So today I've been invited to talk about establishing guardianships. And that may be a new topic to many people. So there's just some basic rules that we need to go through, or observation points, and we'll cover most of those along the way. I'm going to ask Christina next slide to switch the slides for me. It's a lot easier. This paper that I prepared, doesn't look like it's coming up, was managing the guardianship system for families with adult children with disabilities. And it's very clear to say adult children because once they're 18, they can make their own decisions. They may not be able to, or they may be able to partially. So they're going to need some help through the guardianship process, which to many people is new. For our friends who are coming here from other countries, a guardianship may be a concept that is completely foreign to them, because in their country, the children just lived at home. No one ever questioned, and no one ever doubted any of that. There was just a different system. So it is new for many people. Next slide. So what is a guardianship? A guardianship is a legal entity that's established between a guardian, which is probably the parent or an adult sibling or family member, and a proposed ward. The proposed ward is the individual who needs to have the guardianship established for them. So it is a legal concept, and in Texas, it's created through the Estates Code. Next slide. So in a guardianship, there are two basic types of guardianships. There's one where you can be appointed as a guardian of the person, and that guardian will help decision-making as to health, education, welfare, which doctors to see, where are you going to live, how are you going to live. That's the guardian of the person. There can also be a guardian of the estate. And why would you need that? Well, if there is money in the estate that the individual proposed ward owns, then a guardianship of the estate will be required to set up. Why? Because the court is going to want to see that the money is managed properly. the court is going to want to follow an accounting to make sure that that person, the proposed ward, because not until the judge signs the order will the proposed ward become a ward. And not until the judge signs the order and all the requirements have been met will the applicant become the guardian. So we have guardian of the person and guardian of the estate. Well, why would we have a guardianship of the estate? I'm also a personal injury lawyer, and many times we have cases where someone has a severe brain injury in their personal injury case. And we need to set up a guardianship of the estate, because if their lawsuit is resolved, and when it's resolved, monies go into that specific estate and somebody manages that for them. If it's just an adult child with a severe intellectual disability and all they're getting is Social Security, you don't need to set up a guardian of the estate. A guardian of the estate is going to require a bond. It's going to require a lot more court supervision. So you avoid that if you can. Sometimes you just cannot. So just be aware that a guardian can be a guardian of the person or a guardian of the estate or both, and it can be the same person. It can be. I suggest that sometimes some personalities are better fit for each different role. For example, for a guardian of the person, you will want somebody who's really caring, involved, somebody who wants to be helping with the decision making, but that person may not be the best one to manage money. So you may want to consider someone else for the guardian of the estate. And the flip part of that would be too, somebody may be very good at managing money and caring for that, but yet really not have the skills to be a guardian of the person, to care and to be responsible for that. No judgment call, just make sure that you get the right person to do the right job for the proposed ward. Next slide, please. So every time we apply for a guardianship, or even before applying for the guardianship, you have to ask, are there any alternatives to guardianship? Because if you don't ask that, or your lawyer doesn't ask those questions now, they're certainly going to be asked later, and the judge may not proceed with the guardianship if there are alternatives. Next slide, please. So the court is always going to look to see what is the least restrictive alternative. And that's the legal term that they're going to use. Is there anything else that we can do to avoid this guardianship? Why? Because in a guardianship, you're taking the legal rights away from someone, from an adult person, and you're taking those over on their behalf. The court is going to require a very strong showing that taking away those rights were really necessary. And if there's any other way that you can avoid the guardianship, the court is going to say you have not met the least restrictive alternative standard, and we're not going to grant this guardianship. So you don't want to waste your money. You don't want to waste the money hiring the lawyer, filing the application fee, getting everybody served. That could be several hundreds of dollars. So ask the tough questions up front. First of all, in the application, you have to ask, is there a power of attorney? And you also have to ask, is the power of attorney properly signed, or was it effectuated legally? And I say this, a person who has an intellectual disability may not have the legal capacity to know what they're doing. And those are two different things. A legal capacity is, do they understand that they're entering into a contract? Do they understand that they're signing the rights over to somebody else through a power of attorney? So if a person does not have that legal capacity, they cannot sign that power of attorney and effectuate it. They may be able to sign their name, but it really is not effective because they never had the legal capacity to enter into a contract. So a power of attorney is good. Now, for example, I may have situations, we talked about the head injury or the accident earlier. If somebody's involved in a wreck, they have a power of attorney prior to becoming incapacitated or disabled. Then that power of attorney, that's the whole purpose of it, to become effective upon their incapacity. However, if there's an individual adult who already was diagnosed with an intellectual disability, they don't have the authority to do that. So powers of attorney are important. Just because they're signed does not mean that it's effective. Many times clients will come to me and say, here, I just need a power of attorney. And with all due respect, I say, well, that's my job to determine legally what you need or don't need. I'm not just going to throw out a document there because you feel that that's going to make it easier for you, because in the long run, the important person is the proposed ward, not so much the person who's the guardian. So next slide, please. Least restrictive alternative, do we have a power of attorney? And that's one of the questions that you need to answer when you're applying this to is there a power of attorney in place? Let me just diverge a little bit that lawyers who handle these cases must have their guardianship certification. Ask your lawyer, do you have a guardianship certification by the State Bar of Texas? What does that mean? It means that we've taken extra coursework, that we have our certificate, that we've done a lot more research and study and attended courses on this, because you really don't want to get a car wreck lawyer or a family lawyer that's never done this to prepare the application for you. And you certainly do not want to go on your own. Because if you have questions, and it's called pro se, if you have questions and say, well, Judge, how do I do this? The judge or the court will tell you, I can't give you legal advice. And there's so many steps that you need to go through. So just hire a lawyer who has their guardianship certification, and you'll be in good hands. And also, if you need a lawyer who's specific in your language, whether it's Mandarin or whatever, or Vietnamese or anything, make sure you see if you can find a lawyer to help you with that, because it's a very technical and complex procedure. So remember we talked about earlier the power of attorney. That's an alternative to guardianship. The court's going to ask that. Also supports and services. And I believe the rules have changed significantly over the last year, that the court and the legislature are looking a lot heavier into the area of supports and services. And what does that mean? What does that mean? Well, we all know that intellectual disability is a spectrum. It's just a wide spectrum of how severe and how maybe perhaps not severe it is. And there are some people diagnosed with intellectual disabilities who can make their decisions. They can decide where they want to work, where they want to live, and the court is going to look to that. I have had clients, and I've suggested to them that perhaps you don't need a guardianship because your child is able to do some things. He's got a part-time job at Kroger. He's able to get to work, catch the bus. She's able to decide which doctor she likes or she doesn't like. And they may not be able to do it on the level that we do it, but they can make those decisions. So the courts are going to look heavily as an alternative to guardianship, a supported decision-making agreement. And what's that? That's an agreement where the proposed ward, perhaps your adult child or adult sibling, and you come to an agreement and say, I, as a proposed ward, can do these things. I can decide where I want to live. I can decide how I take care of my physical health. I can decide which doctors I want to see for my mental health. I like Dr. Jones. I can handle basically my money. I may not be a whiz, but I may be able to put the change and to go to the store and buy a hamburger or something. And I had that happen one time. So you can do these things. I can also decide whether I want you to help me find a job or whether I can do it on my own. Those are some of the decision-making aspects that the court is going to look for. So don't jump over those, because again, the levels of incapacity or disability or intellectual disability are very wide and open. And somebody can say, well, I can do some of these things. So let's go to the next slide. So we've decided that there is no power of attorney. We've decided that supported decision-making is not going to work. And that's then when you talk about a guardianship. Make sure you cover those hurdles first, because if you don't, you're going to get to court and you might be embarrassed because the judge is not going to allow this because there was what? There was a lesser restrictive alternatives. So now we've gotten to the point where we need to obtain a guardianship. And I've got 6 basic steps. There's a lot, many sub levels to this, but 6 basic steps on how to attain a guardianship here in Texas. Next slide, please. The first thing that you want to do if you feel that there's a need for a guardianship is to what we call just a doctor's letter. It's the physician's certificate of medical examination. It's just a doctor's letter. Don't, however, get a letter from your doctor and your doctor's letterhead that says my adult child is diagnosed with this level of intellectual disability. That's not going to work. It needs to be this form. And every physician, I guarantee you, who treats adults with intellectual disabilities is aware of this form. Have them fill this form out and get it back to your lawyer as soon as you can, certainly within 120 days. Why? Because the judge is going to want to see that the application and this certificate of medical exam are pretty close in time. He or she doesn't want to have a letter that says the physician saw the proposed ward 18 months ago, because the court's going to want to know what is the situation now. So this is a very time-sensitive document. The physicians know about this and make sure that they get that back to you timely, because it needs to be filed close to the time. I like to file them at the same time as the application for the appointment of the guardian. Okay? Any questions so far on anything?
I think we're good.
Okay, good.
Or
So
did someone have a question?
Leslie typed a question. It says, do you need guardianship of the estate if there is a third-party special needs trust?
you could probably get by without if you have a special needs trust. And special needs trusts are going to be a lot more expensive, a lot more to manage. And many times I do see those. So that's a very good question. Yeah, if the terms of the special needs trust provide that the funds will be in there, then you may not need guardianship of the estate, and you need to check with the court on that. Now, you will still have to file an accounting at the end of every year, and that's important too. So good question. So now that we passed the physician's certificate, let's move to the next slide. We have this filled out. Then we need to find where are we going to file this application for the appointment of the guardian of the person and estate. This is just an example of person and estate. So where do we file this? It depends on which county you're in. Certain counties, like Harris County, have probate courts, and probate courts handle jurisdictions for guardianships. Well, what is a probate court? We have 5 now in Harris County. 5. That's amazing. It's a court that's set up specifically for cases of probate and death, probating wills or administering estates where they don't have wills, and also with guardianships. What happens if you live in a smaller surrounding county that does not have a probate court? Then you need to ensure that it's filed in a court that has probate jurisdiction. What it means is that certain one of those county courts, that judge is more familiar with guardianships, so the cases will be filed there. I say all of this because there's a lot to preparing this application. There's a lot to filing it. And then you need to serve the proper people. What does that mean? That means if there's siblings or parents that are part of the family, they need to be given notice. And it just depends on the age, how they're given notice, when they're given notice, or if they need to be given notice at all. That is pretty complex. So you're going to have to leave that up to your lawyer to review the estates code to find out who needs to be served. Can they just sign a waiver and say, hey, I understand everything? Certainly they can, but they have to have the capacity to do that. You can't have a 6-year-old saying, oh, I'm going to waive this in favor of my mom. So the court's going to look at all of those things. That 6-year-old may be the sibling. Siblings have to be brought in, have to be given notice of this. I say all of this because it's not just a matter of filing the courts. You've got to have all the steps. And the court's going to want to see that your lawyer signs a certificate saying that they've taken the certification and that they are certified in guardianship law. So that's the next step, filing in the guardianship court. Next slide, please. Now that you have this filed in the court, you're going to be waiting for the hearing to come up. And the hearing is when all the magic happens. In the meantime, your lawyer who is representing you, that's really important. Your lawyer represents you as the proposed guardian. Your lawyer does not represent your adult child as the proposed ward. So how do we handle this? As the applicant, your lawyer must file an application for the appointment of an attorney ad litem. And what does that mean? That just means that that is going to be a lawyer that is going to represent your adult child. Because remember, we are in an antagonistic legal setting, meaning that, yeah, you love your child, it's all beautiful. However, you're taking their rights away. So the court's going to want to appoint another lawyer for your adult child, and that lawyer represents them. That lawyer needs to go to the hearing. That lawyer needs to go to your house. That lawyer needs to visit your child. That lawyer needs to be involved. They need to write a report. They need to review all of the medical records. And in the end, they'll go to court with your lawyer and say, Your Honor, based on all of the evidence, I believe that a guardianship is necessary. And here's why. So the courts don't take this lightly. If you have a Spanish-speaking client, ask the judge to appoint a Spanish-speaking attorney ad litem. They are out there. Or any language that you need. Ask the judge, but chances are they have one. At the hearing, definitely tell your lawyer, I need an interpreter for whatever language it'll be, and they'll have an interpreter there for you as well. So that's the role of the attorney ad litem. The rules, which were recently enacted, have changed a bit. And before, it used to be that, well, we would just file the application for the attorney ad litem. However, if your adult child does not like that person, they can say, I don't like him or her. And the judge may ask, well, would you like to have someone on your own? And again, it depends on the level of disability or the level of incapacity. It's a very fluid area. So the judge will try to see that. But the rules have changed under the Supportive Decision Making Act, that now there is more liberty for the proposed ward to ask what they want out of this. And if they don't like the attorney ad litem, they can voice that, and the judge may get another, or maybe get some input from them as to who they would like and why. So number 3 is appointing the attorney ad litem. Super, super important. And the attorney ad litem is really got to step up and do what they need to do, go visit with the proposed ward. So what do they charge? In Harris County, the most that an attorney ad litem can charge is $700. I won't say the same in Fort Bend. I won't say the same in other surrounding counties. Many of them, it just depends on the hours that they put in, and they can prove to the judge the work that they put in. Could be 1,000, could be 1,500, could be 2,000. It just depends on what the court's going to prove. Harris County is going to limit that to $700. So whatever you're paying your lawyer, you also need to be aware that that is an additional amount that you're going to have to pay on that. So can we switch slides? Attorney ad litem, that's important. What is the next step? The report of the court investigator. Here's why that's important. The court investigator is going to be the right-hand person to the judge. It is just another safety valve. The court investigator is going to go to your house. They're going to visit with a proposed ward. They're going to visit with you. They're going to see what the house looks like. They may go to the school. They may go to the facility that the proposed ward attends during the day. They're going to review all of the records, and then they're going to go back and report to the judge. Judge, this is what we saw, and we too agree that a guardianship is necessary. They may find out that they go and, oh, my son's not home. He's working at Kroger today, and they'll go visit him at Kroger. And if they see that he or she can manage, then if she can manage that, then they may say, wait, there are different alternatives here. So we don't need to have a guardianship because this person's able to manage things on their own. I think I saw one of the questions popped up that said, when should I start this? I always say when your child is about 17 and a half, get ready so that you can know the process. You can decide when you need to get the doctor's letter. Just start thinking about things. The worst time is when you're in the hospital and the nurse says, I'm sorry, we need his or her decisions because they're an adult. That is not the time to get a guardianship. And it does happen. So prepare in advance, start at about 17 and a half. Feel free to talk to your lawyer about what needs to be done, the timelines of things that need to be done, so that when you turn 18, it's already there. On many of them, I will file before the 18th birthday. And so that when they turn 18, the wheels are already turning. So
Jim,
just use your judgment, but you don't need to start when they're 7, 8, or 9. Just know that you'll do it down the road.
I just got a message. So if somebody has, they don't have guardianship, but they have a medical power of attorney, that does allow doctors to speak to them should their child be hospitalized, things like that, correct?
Correct. However, that child must be an adult child.
Yes.
And they must have capacity, legal capacity to sign that power of attorney.
Right.
Yes. And if
Okay.
that's the case, then yes. And there's a medical power of attorney and a financial power of attorney. So you want to make sure you distinguish between the two documents. Okay.
So does financial, is durable power of attorney, does that include financial?
Yes, a durable power of attorney is also known as a financial power of attorney.
Oh, is it?
Yes.
Okay, I did
Yes.
not know that. Learn
Yes.
something new
Yes.
every day.
Yes, and
Got
a
it.
statutory power of attorney is also a financial power of attorney. You distinguish it from a medical power of attorney, which is just called a medical power of attorney. But the others just have many names. So you want to distinguish those two. And of course, you don't want to take your financial power of attorney to the hospital because they're not going to do any good. They need to have
Exactly.
a medical power of attorney. Okay?
Thank you.
So, my pleasure. So we have the report of the court investigator. Very important. When they say they're going to come by, be there. Treat them kindly, respectfully, because they're the ones that are going to be reporting back to the judge. Can we switch slides, please? Okay. So the fifth step that we need to do is a guardianship training course. Don't let this underestimate the importance of this, because if you don't have this done, you don't get to set the hearing. So a guardianship training course is just that. You need to go online and take a course, answer the questions, fill it all out properly. And once you do, you'll get a receipt stating that you've completed the certification. When I set the case for hearing for the judge to grant the guardianship, they're going to look at that. The court investigator is going to say, yep, it's there. It's in the system. I saw it. Or they're going to say, no, we're not going to set this hearing because you haven't taken the certification. It is in English and it is in Spanish. So I many times have had clients come up to my office. I'll set it up for them. I won't take it for them, of course, but I'll tell them, here, we have internet. Here's what it looks like. You click the right answers to this. And it's a lot less intimidating because sometimes they just don't know how to get these things set up. But it's important. You've got to have your training course. You've got to have it on file if you want to go to the hearing and have the appointment made. Next slide, please. So we've gotten to the day where we have the hearing. This is step number 6. And the hearing is when the judge is going to take all the evidence into consideration. The hearing is when the judge is going to review that doctor's letter that you started off with. The judge is going to see if there is a medical or financial power of attorney. The judge is going to look to see if have there been any supportive decision making? Has there been any alternatives to guardianship? They're going to look at all of these things. And at the hearing, if they feel that there is a clear and convincing need to establish the guardianship, then they will. So who needs to be at the guardianship? You, as the proposed ward, need to be there. Your lawyer needs to be there. The attorney ad litem needs to be there. Now, does your adult child need to be there? Not necessarily. That is not a call that I make if I'm representing you, the applicant, in court. That is a call that the attorney ad litem, who is appointed by the court and is representing your adult child, it is for that lawyer to say, Your Honor, my client is not here because of the following. There are many situations. One could be, when I was an attorney ad litem, I've had clients who could not make an elevator ride because it was so overwhelming in an enclosed space. They could not attend a hearing because there were so many people there that was intimidating to them. The ceiling lights, maybe the noise, the traffic. Of course, remember, there's all different levels of disability. So depending on what is impaired with, the attorney ad litem may say, Your Honor, based on that, or the difficulty of getting here, or she's in a wheelchair, I respectfully ask that the court that my client not attend. But you got to make sure the judge approves that. So you want to have your lawyer check that out before. So we're at the hearing. Everyone gives testimony. I prepare my clients well ahead of time with the questions that I'm going to ask them. There are no tricks, there are no surprises, nothing hidden. You just want to make sure that your client is comfortable, that they know what they're going to ask, and what you're going to ask them, and what the attorney ad litem is going to ask as well. So the attorney ad litem will be able to get a chance to ask you some questions, and they're usually very, very simple questions like we met before, and do you agree with me that a guardianship is necessary? Next page. So we've done everything right? We've applied, we're in the right court, we've met all the requirements, we have no lesser restrictive alternatives, we've gone to court. This is the end result that you want, the certificate of guardianship. This is the key, the gold key that you're going to have to go to the hospital, to go to the bank. Now remember, in this letters here, it's going to be a guardianship of the person or a guardianship of the estate. And here it says in this one, it's the guardian of the person of Matthew Paul Block. So had it been a guardianship of the estate, it would have been listed in there as well. So these letters of guardianship are the end result of what you need and what is going to allow you to move forward on behalf of your family member or your proposed ward. Caveat, these are going to expire probably in about a year, 2 months, I believe. Why is that? Because the court is going to want to be confident that the guardianship is continued. This just doesn't go on forever. Many times people get better. And clients that I have that have traumatic brain injuries, many of them can get better and they no longer need a guardianship. So the court is not going to keep that going. Every year, you're going to have to file a report. It's a very simple report. There's a report as to how everything is going. Are we seeing the same doctors? Are we still living in the same house? Is everything the same? Everything continued? The judge is going to look that over. They're also going to look at the finances. If you're the guardian of the estate, they're going to have a breakdown of everything that you've spent, and you need to have backup receipts showing what you spent on the proposed ward. One of the judges used to say, take two shopping carts when you go shopping, one for the proposed ward and one for yourself. Don't commingle anything. You run everything up here. That way you can show on the receipt everything that belonged to them. So the reports are essential for you to renew the guardianship. Many times clients forget to do that, and then they call me up in a panic because they get a letter that, oh, my guardianship is going to be DWOPed, means dismissed for want of prosecution, which means that they're going to stop the letters. I said, well, just get in your report and I'll help you with that, and then you'll get your letters renewed. So this is really important. The letters of guardianship are not permanent. They need to be renewed, and you need to do your part to file the report timely so that you can get these. So I ask, after the hearing, mark it on your calendar a year from there to send in that report, because it's easy to forget unless it's on your calendar. and then you'll submit that and your guardianship will continue.
Jim, a couple of questions.
Sir,
One is, we sometimes have parents who say, my adult child is an only child, I'm an only child, his mom passed away or vice versa. Don't really have close family and friends. They have guardianship. What happens when the parent dies? Is there someone who can be trusted that will look out for this adult who has guardianship over them?
very good question, and it happens. I've had clients say, well, I'm just going to give my guardianship over to my brother-in-law. Well, you can't just give it over to your brother-in-law
Right.
because you were appointed by the court.
Right.
Only the court can do that. So you need to file an amended application for guardianship,
Mhm.
and that person starts all over. That the previous guardian is no longer able, or they're deceased. So we want to continue with the guardian. So in other words, you cannot delegate it to somebody else. It has to be the court that appoints you. Yeah, and that happens quite often. People think, I'll just give it to someone else.
So, but say somebody knows up front, hey, I don't even know who to give it to.
Well, then the courts have guardianship advisors, guardianship centers, and sometimes you need to have a professional guardian to do it. There are services for that.
So that was my next question. That was another question.
Right.
How do you find, for parents on this call who might be in that position, how do you find those trusted guardianship services? Because we all know there's good and not so good in every profession.
Right. I would call up the court that you're in and say that here's the situation. And there are professional guardians who have worked in the court system.
Right.
And they have now set up their own profession. So they know what they're doing. I know some of those people, and they've been doing this for years. And it's just they follow all the rules, and there are professional guardians. So you can check with the court on that.
Check with the court. Okay, that's good to know.
Yeah.
And is there a cost for those services?
Yeah. Yes.
How does that get paid?
Well, it's just if the court approves it, maybe you could pay from the money of the proposed award.
Okay.
Or pay it on your own and they get reimbursed. But yeah, just check with the court on that, see how they want to handle that accounting. So it does happen. I've had very few situations of that with professional guardians, but they are out there.
Okay, thank you.
My pleasure. Any other question? Let's see, does anyone have?
And Leslie also put, you can list your preferred successor guardians in your paperwork. Yes, absolutely. And can a person have more than one guardianship? Great question, Sherry.
Well, we discussed a guardianship of the person and a guardianship of the estate. So those are two separate. But are you asking if there can be two different guardians? That's different. You can only have one guardianship. It may be multifaceted in this guardianship of the person, guardianship of the estate, but there's still one guardianship. Because it's one.
What about co-guardians?
Co-guardians, yes, you can. Yes, you can. Generally, husband and wife. Personally, and then these letters of guardianship that are on the screen, there are co-guardians. I don't, unless it's husband and wife, I don't particularly care for it because one person may have one decision and another has, and then there's a tug of war. Right. Same thing when it comes to wills. I don't care for co-executors because someone may say, well, dad told me this, and but dad told me that, and I'm going to do it a little different. So I prefer to just have one person. If they resign, then we go down to the next. But husband and wife co-guardians are common.
And Sherry, if we didn't answer that question, please let us know. I got another private message. Do you have to renew the supported decision-making agreement every year or so? And you do not need a power of attorney and a supported decision-making agreement, right?
You don't need if you have the power of attorney, you've got the power of attorney. Yeah.
Right.
Now, because the supported decision-making agreement is new to me and the rules have changed, I don't know the answer if it needs to be, I'd have to look that up, if it needs to be renewed. I know that it can probably be revoked at any time. If the proposed says, I don't want it anymore, it can be revoked. But as far as renewal, I wouldn't think so. I'd just have to look at the rules a little closer.
Yeah, and I can say from personal experience, because that's what I have for my son, I have it, and I've had it for, gosh, probably 10 years now,
Yeah,
and it has not been renewed, but what I do is have it reviewed every 4 or 5 years,
I think it's a good idea. Yeah,
just to make sure no laws have changed, dot I's, cross T's, and I get another attorney's perspective.
sure, absolutely. Yeah, and some of the needs may have changed.
Exactly.
Some of the needs may have changed, are no longer necessary. So that's a good practice. Yeah.
Yes.
So let's see. Can we move to the next slide, please? So here's just a summary of what we discussed. Remember that medical examination certificate? Make sure that it's fresh. Make sure that it's timely within 120 days. We file the lawsuit in the appropriate court. Remember, we're in Harris County, we know where to file it, but smaller counties may have county courts with guardianship jurisdiction. We need to make sure that the attorney ad litem is appointed and be aware that that's going to be a separate cost for you. Report of the court investigator is supremely important. Be very receptive, friendly, allow them into the house. When they say they're going to be there because you want to make their job easier because you want them to write up a nice report and everything favorable. The guardianship training course, if you don't have that certificate, you're not going to pass go. You're not going to be able to set for hearing. If you need help, just go into your lawyer's office and say, hey, can you help me set this up? And so that I can take this and get the certificate. And at the hearing, remember, be there. Many of them are still by Zoom. Your proposed ward may or may not have to be there. Just depends on the proposed ward and the attorney ad litem and getting permission from the court to excuse. Next slide, please. So those are the 6 basic steps. If anyone has any questions about anything, this is all start at what age? Again, I like to start this at about 17 and a half because, next slide, because I want to get everything rolling. I want to make sure that we get this guardianship set up as close to their 18th birthday thereafter as possible so that everything goes on smoothly. I have many clients, sometimes wait till they're 30 or 40. They've really gotten a long way, but yeah, and nothing sooner than when they're 18 because they need to be an adult. So here is my contact information. Here is, I can be reached out, text me. That's the only number I have. Email me, and I'll be happy to answer your questions and let me know that you were part of this presentation. So I'm open for any questions that anyone.
Jim, that was so helpful.
Oh, thank you. My pleasure.
Really, really great. I got another, and also I put in the chat box, if you have to leave, I put in the survey link. So please make sure you complete the survey. We all know Jim is great. We want to make sure you believe he's great too, and that he helped.
Thank you.
We have a question. I have a 14-year-old daughter. Is it too soon?
I would say yes. Yes. Yeah, because until your daughter is 18, you're still their natural. It's only after she turns 18 that she's going to need a court-appointed guardian. So you can make decisions just like you would any other child while they're still minors. Yeah, so 14 is too soon, in my estimation.
Got it. So you're saying about 17 and a half.
17 and a half start, yeah. Mark it on your calendar, start getting everything in order. Remember that doctoral certificate is very, very timely, so we don't want to do it too soon, but just get things rolling.
I have a question, if I may.
Sure.
My pleasure.
Hi, this is Mercedes. What if you're in between, like your child's already 18, still going to school, and can you ask the lawyer for a letter to the school letting them know that the guardianship is under process?
Certainly.
Because some of the schools won't invite the parent to the IEP if the student's already 18, they don't have to. Thank you for the answer.
Yes, if you need, I often write letters that a guardianship or a lawsuit has been filed. Somebody needs to have that letter. So yes, it would be helpful to let them know that it's in progress, and that way you can go to that meeting. But again, I'm a big proponent of find out what they want and give them what they want. And if they want a letter, give them a letter. If they want the letters of guardianship, that's why you started early, right when they turned 18. You're going to get those letters of guardianship, and you don't miss a step because you can just hand them that, and that's the key. That's the golden key to everything. So
Great
yeah.
question. Thank you, Mercedes. Another question. So someone does not have guardianship of their loved one, and Gina, we'll get to your question in just a second. Someone does not have guardianship of their loved one, and now there's some mental health challenges, and they're in their early 20s. So we all know that even with guardianship, you can't force somebody to take medication, correct?
Correct.
So it doesn't prevent them from getting arrested. But the parent is asking, how can I now that there's these mental health challenges, is it the same process reaching out to an attorney?
Yes.
And
Yeah.
okay.
You're just going to have different levels to deal with. Certainly, the guardianship is still needed. The guardianship is needed. However, it's that once someone becomes combative, and there are many cases where someone is combative, and if this proposed ward under the new relaxed rules says, "Well, I don't want this law, or I don't want this guardianship," it may not go forward, and you're just in a tough spot.
Right.
And I see a lot of it. I see mental health. I see drug addiction. I see HIV positive. There's a lot of issues that come with adults, not kids, not adult kids, but the person who may have been living on the streets for a while.
Right.
I was often appointed as attorney ad litem for those, and it's really,
It's heartbreaking.
really it is.
It's absolutely heartbreaking, and we
Yeah.
get calls like that.
Yeah.
So another question, and I'm glad you asked this, Gina, because I was talking to Jim before we all started, and I said, if every attorney was like Jim and worked with our families, wouldn't life be great? And because how much does a guardianship cost?
Well,
And
I will, yeah. It can be expensive. I charge $5,500. If you tell me that you're with family to family, I'll have a reduced fee there, but I include all of the expenses. I'm not a lawyer. I'm a charge of the phone calls, for the office visits, for the
Right.
filing fees, for
Right.
this and that. I've been doing this long enough that it's just a flat fee. The only thing I don't include is the attorney ad litem fee, because I don't know what he or her will charge. I know it may
Right.
be up to $700, but I don't want to charge you that if they're not going to. So
Right.
I work with family to family members.
Thank you.
Thank
We
you, Jim, as always.
Yeah, we really appreciate that. And then you wrote, do you have to every year? And I think what you meant is, do you have to renew it every year? And I think you said that there's a form that needs to be completed, but you don't need an attorney for that?
You do not need an attorney for that. What will expire are your letters of guardianship. So
Okay.
they will have expired. So the guardianship is still going. It's still in the courts, but it may be inactive because you haven't updated your report. So make sure you get those reports done as soon as you go to the hearing, as soon as you're appointed, put a year later so that you can get that in timely and keep those
And
letters of guardianship going.
does somebody send them the reminder? They just have to put it on their calendar? Do they need an attorney to renew it?
They'll send you the reminder when it's delinquent.
Okay.
They'll send the lawyer, oh, by the way, we're going to dismiss the guardianship, and then everybody's in panic mode. So that's why I say either the lawyer or the client, or both, mark the calendar a year from the appointment,
Okay.
and we're one step ahead of it. Yeah.
And then that's another cost. Yeah, it's very challenging. Very, very challenging. I can tell you that if you're on this call and you do want supported decision making, sometimes there's some of the law clinics, Disability Rights Texas, they do help with that, but there can be a wait. They get very overloaded. We love Jim Soto. He has been a longtime friend of Family to Family Network. And as you can see, he's knowledgeable and very good at answering our questions.
Thank you.
Any other questions, thoughts? Oh, another question. Do you also deal with child support cases?
I do not. I do not. And that is interesting because child support And child custody
Mhm.
will probably be in the family courts.
Right.
That's a whole different area. What we're talking about is guardianships in the probate courts. That's my
Right.
area of practice. Yeah.
Right. Okay.
Okay.
I think I got all of the questions.
Yeah, I didn't see any more.
Yeah, I think we're good. And if you do have any questions, feel free to reach out to Leonella, Christina, Leslie, or myself. And we're happy to, or you can reach out to Jim. And
Certainly.
please, again, complete the survey. It's really important. We get grant funding, and people need to know, our funders need to know that this information has been helpful. I will publish the survey again in the chat box. Please complete it. And if there are not any other final questions, Jim, we thank you so much. If you know of anyone that you think this information will be helpful to, please introduce them to me. I need them to just register and add them to my list. And I am happy to send them the recording link and the PDF slides so that they too can be educated. If you know of anyone who speaks Spanish and would like to watch Jim again for an encore performance, June 19th at 6 p.m. Central Time, please introduce them to me. I'm very good at Google Translate, and I am happy to send them the recording link, the Zoom link, and they can join us next Wednesday.
Great.
You are very welcome, Margarita. So thank you all so much for joining us. We truly appreciate it. Have a great rest of the day.
Thank you all.
Thank you,
Thank you,
Jim.
Jim.
See you
My
next
pleasure.
week. Bye-bye. Thank you all.